Welcome to Swadharma IAS Academy. I am your lead lecturer for today's comprehensive session.
It's great to be here.
We are about to embark on a journey through, well, what is perhaps the most critical, high-yield, and intellectually stimulating portion of the entire Indian Constitution.
I'd have to agree. You can't really overstate its importance.
No, you can't. And we're not just reading articles today. We are, in a very real sense, decoding the DNA of our democracy. Now, before we begin, a quick reminder to all the serious aspirants watching.
Yes, please pay attention to this part.
Please watch till the end for complete conceptual clarity, and don't forget to like, share, and subscribe to Swadharma IAS Academy. It really helps us continue these deep dives.
It does.
So today we are discussing the Magna Carta of India. We're analyzing the cornerstone of our legal system fundamental rights, which are covered in Part 3 of the Constitution, spanning from Article 12 to Article 35.
It's a pleasure to be here. As a senior aspirant who has, navigated the treacherous waters of prelims and mains a few times, I know this isn't just a chapter you read once and move on.
Not at all. It's foundational.
It's the heart and soul of the syllabus. You quite literally cannot get through a polity paper without facing questions from Part 3. My role today is to represent the student's voice, to ask the specific doubts that usually pop up in the exam hall.
For instance.
Well, when we get confused between procedure established by law and due process of law, or when we struggle to understand the nuances of the basic structure or doctrine, those kinds of things.
Precisely. And that's our objective today, to move far beyond rote memorization. Any book can give you the text of the articles.
The text is easy to find. The understanding is harder.
Exactly. Our goal here is conceptual clarity. We want to understand the spirit of these laws, the dramatic evolution of judicial interpretation from, say, A.K. Gopalan all the way to Puttaswamy, and that delicate balance the Constitution strikes between individual liberty and state control. So let's dive straight into the philosophy of it all.
Let's start with that philosophical foundation. We use the word right very loosely in daily life. But for a UPSC aspirant, we need a precise definition. What exactly are rights? And, I guess, why do we classify some of them as fundamental?
A great starting point. To understand rights, you first have to imagine a life without them.
A thought experiment.
Yes. Imagine a scenario where the police can storm your house without a warrant, where you can be thrown into jail simply for speaking your mind, or where your property can be seized by some whimsical ruler without any compensation.
That sounds like a tyranny.
It is. That is a life of oppression. It's a life of subjects, not of citizens. So rights are essentially claims. They are claims that are recognized by society and, crucially, sanctioned by the state. They are the conditions of social life without which, no person can seek in general to be at their best.
And this is where we get into the different types of rights.
Yes. Broadly speaking, we have two major philosophical buckets here: natural rights and legal rights.
This is where the confusion often starts for beginners. Natural rights are often associated with Western philosophers like John Locke, correct? The idea of life, liberty, and property.
That is correct. The logic of natural rights is fascinating, and you could say somewhat romantic. It suggests that rights are given to you by nature or by God, not by a king, a parliament, or a government.
So they exist outside of any man-made law.
Precisely. The argument is, if nature gave me life, a king cannot arbitrarily take it away because the king did not give it to me in the first place. My life is not a gift from the state. Therefore, the state has no business extinguishing it without a very, very good reason. These rights are inherent to your existence as a human being.
But there's a problem with that, isn't there? What's the enforcement mechanism?
And that's the strong counterargument. Natural rights can be very abstract. If I claim a natural right to my property, but a strong man comes and takes it, and there's no police or court to stop him, that right is effectively meaningless. It's just an idea.
Which brings us to the concept of legal rights.
Exactly. Legal rights are rights bestowed by the state or by the law. They are enforceable. You can go to a court and say, the law gave me this and it is being violated. Now, the genius of the Indian Constitution is that our fundamental rights are a blend of these two philosophies.
So they're not purely one or the other?
Not at all. They are essentially natural rights, like the right to life, liberty, and expression, that have been codified. They've been written down into the fundamental law of the land, which is the Constitution. And because they're written in the Constitution itself, they aren't just rights, they become fundamental rights.
And their purpose?
They act as limitations on the tyranny of the state.
So in a way, fundamental rights are negative obligations on the state. They are mostly about telling the state what it cannot do.
For the most part, yes. That's an excellent way to frame it for an exam answer. They are claims of the citizens against the state. They prevent the state from becoming, well, a monster. They say, state, you cannot discriminate. State, you cannot silence us.
But you said for the most part, are there exceptions?
There are, and this is a crucial point for prelims. Not all of them are negative. Some are positive obligations. For example, Article 21A, the right to education, compels the state to do something. It compels it to provide education. But historically, this entire concept evolved from a long lineage.
Right, it didn't just appear out of thin air in 1950.
No, you can trace it back to the Magna Carta in 1215, where King John was forced to limit his own powers. Then, through the Bill of Rights in 1689 in England, the French Revolution's Declaration of the Rights of Man in 1789, and of course the U.S. Bill of Rights.
In the Indian context.
In the Indian context, the Motilal Nehru Report of 1928 was a major milestone. It was where we, as a people, explicitly demanded these rights from the British colonial government. That demand culminated in Part 3 of our Constitution.
It's interesting you mentioned the state becoming a monster. That leads us directly to the very first article of Part 3 we need to discuss, Article 12. If fundamental rights are a shield against the state, we absolutely must define who the state is to know who we're protected against.
Correct. Article 12 is the dictionary for Part 3. It defines the state, and it includes the obvious entities: the government and parliament of India, that's the union executive and legislature, and the government and legislature of each state.
The central and state governments?
Yes. But it goes further. It includes all local authorities, municipalities, panchayats, district boards, improvement trusts, all of them.
That seems straightforward enough, but the controversy and the exam questions usually lie in that phrase, other authorities, don't they? That term seems incredibly vague.
That is the catch-all phrase, other authorities. And the Supreme Court has interpreted this very, very widely to ensure the state cannot hide behind corporate veils or technicalities.
So what does it include?
It includes public sector undertakings, PSUs, like LIC, ONGC, SAIL. The logic is simple. If a body is financially, functionally, and administratively dominated by the government, it is the state for the purpose of Part 3.
So if LIC discriminates in its hiring, it can be challenged as a violation of fundamental rights.
Precisely. And listen to this carefully, because it's a common point of confusion. Even a private body can be considered state under Article 12 if it is working as an instrument or an agency of the state.
Can you give an example of that?
Certainly. Imagine a private security agency that's been hired by the government to manage security at a major airport, or a private company that has been contracted to perform a public function, like distributing food grains. In those specific functions, they are considered state and cannot violate your fundamental rights.
Okay, that's a very important distinction. Now, sir, a very common doubt that aspirants have. Does the judiciary fall under Article 12? Is the Supreme Court the state? Because if the state cannot violate rights and the court makes a judgment I don't like, can I sue the court for violating my rights?
This is a nuanced area often tested in the mains. The current position, which has evolved through cases like Rupa Ashokara and Naresh Murashkar, creates a very clear distinction.
Okay.
When the courts are performing their judicial functions, so delivering judgments, sentencing people, interpreting the law, they are not considered the state.
And why is that?
To prevent the entire legal system from collapsing, if every judgment could be challenged as a violation of fundamental rights, there would be no finality to any case. So for judicial functions, no. However, when the courts act in their administrative capacity, say the Supreme Court hiring staff, making rules for its employees, or conducting exams for court clerks, in those roles, yes, they are the state. They cannot discriminate in their hiring practices, for instance, just like any other government department.
That distinction is vital, judicial versus administrative capacity. Now, moving on to Article 13, this is often called the protection shield of the fundamental rights.
It is. Article 13 provides the teeth for Part 3. Without Article 13, fundamental rights would just be good advice or, moral platitudes on a piece of paper.
So what does it do?
Article 13 declares that any law that is inconsistent with or in derogation of the fundamental rights shall be void. This one line explicitly establishes the doctrine of judicial review. It empowers the Supreme Court under Article 32 and the High Courts under Article 226 to strike down unconstitutional laws. It effectively says that the Constitution is supreme, not the Parliament.
And the term law here is defined very broadly in Article 13.3, right? It's not just talking about acts passed by Parliament.
Yes, and this is a potential prelims trap. You must know this definition. Law includes acts of Parliament ordinances issued by the president, orders, bylaws, rules, regulations, notifications, and even customs or usages that have the force of law.
So a social custom can be struck down.
Absolutely. If a village custom says Dalits cannot walk on this road, that custom is law under Article 13, and it is void because it violates Article 17. The Constitution, you see, overrides centuries of social tradition if that tradition violates fundamental rights.
Okay, and within Article 13, there are two key doctrines the courts have developed. The first is the doctrine of severability.
Yes. For Mainz, these doctrines are very important. The doctrine of severability is the idea that if a part of a law is bad, you don't have to throw out the whole law, you just cut out the bad part.
Sever it.
Exactly. You sever the diseased limb to save the body of the law. In the famous A.K. Gopalan case, Section 14 of the Preventive Detention Act was found to be unconstitutional. The court didn't strike down the entire act, they just removed Section 14. The rest of the act remained valid. The logic is that the judiciary should try to save the legislation as much as possible, not strike it down at every opportunity.
And the second doctrine is the doctrine of eclipse. This one's a bit more complex.
It is, and it applies primarily to pre-constitutional laws. So laws that were made before January 26, 1950. Imagine a law from, say, 1940 that discriminates against women.
Okay.
On January 26, 1950, when the Constitution comes into force with the right to equality, that 1940 law doesn't necessarily die or get repealed, it just gets overshadowed. It is eclipsed by the new fundamental right. It becomes dormant or unenforceable.
So it's not dead, just sleeping.
Exactly. And if in the future the fundamental right is amended and the conflict is removed, that old law can wake up again. It revives. It was sleeping, not dead. That's the doctrine of eclipse.
So this brings us to the biggest debate surrounding Article 13, the one that has defined our constitutional history. Its relationship with Article 368, the amendment power. Is a constitutional amendment considered a law under Article 13? Can Parliament amend fundamental rights?
This is the great conflict of Indian constitutional history. It's a fascinating tug of war between parliamentary sovereignty and judicial supremacy that really defined the first 30 years of our republic. To understand it, you have to trace it chronologically. The story matters.
Let's start at the beginning then.
In 1951, in the Shankar Prasad case, the Supreme Court took its first stance. It said, no, a constitutional amendment is not law under Article 13. It's an exercise of constituent power, not legislative power. So Parliament is supreme. They can amend anything, including taking away your rights.
But that position didn't last forever. It changed in 1967 with the Golaknath case.
It changed drastically. In Golaknath, the court performed a complete 180-degree turn, a full reversal. They said fundamental rights are sacrosanct and transcendental. They ruled that an amendment is a law under Article 13, and therefore Parliament cannot amend fundamental rights to take them away or abridge them.
And how did Parliament react to that?
Well, Parliament was furious. They felt the court was acting as a roadblock, stopping them from implementing socialist reforms like land redistribution. So they responded with the 24th Amendment Act in 1971.
What did that amendment do?
It explicitly wrote into the Constitution that Parliament has the power to amend any part of it, including fundamental rights, and it specifically stated that Article 13 does not apply to amendments made under Article 368.
A direct challenge to the Supreme Court's ruling.
A direct challenge. And this set the stage for the most famous, most important case in Indian history, Kesavananda Bharati versus State of Kerala, 1973.
The OG case, as you called it.
The OG case. The Grand Master of all judgments, a bench of 13 judges, the largest ever. The Supreme Court took a middle path that many argue saved Indian democracy.
What was this middle path?
They upheld the 24th Amendment. They said, okay, Parliament, you have the power to amend fundamental rights. You can change them. But and this is a massive but, you cannot destroy the basic structure of the Constitution.
The basic structure doctrine.
Exactly. They said you can amend the text, but you cannot kill the soul. Things like secularism, the rule of law, judicial review, democracy, free and fair elections, these are part of the basic structure and cannot be touched by Parliament, not even by an amendment. This put a permanent, ingenious check on Parliament's power.
That clarity is absolutely essential for the exam. So, to summarize, fundamental rights are amendable, but not if the amendment hits the basic structure of the Constitution.
You've got it.
Okay, let's move to the specific rights now. The right to equality, which is Articles 14 to 18. Article 14 mentions two phrases, equality before law and equal protection of laws. Are these just synonyms?
Not at all. And it's a common mistake to think so. They are two different but complementary sides of the same coin of equality. Equality before law is a British concept. You can think of it as a negative concept.
Negatives in what sense?
It means no one is above the law, the absence of special privilege. Whether you are the prime minister or a peon, if you commit a murder, the law sees you simply as a murderer. This is directly connected to A.V. Dicey's concept of the rule of law.
And we adopted Dicey's concept wholesale.
Not entirely. A little nuance for Mains. India only adopted the first two of Dicey's three principles. That is, the absence of arbitrary power and equality before the law. We rejected his third principle, which was that the Constitution is the result of individual rights. In India, it's the other way around. The Constitution is the source of our rights.
I see. So what about equal protection of laws?
That is an American concept, and it is positive in nature. It means, like, should be treated alike. It allows for reasonable classification.
Can you explain that?
Of course.
Yep.
You cannot treat a billionaire and a below-poverty-line citizen equally when it comes to taxation. Taxing them both, say, 1,000 rupees would be deeply unfair and unequal. So equals are treated equally and unequals are treated unequally. This principle is the constitutional basis for all affirmative action and reservation policies. The state can make special laws that benefit specific groups if there is an intelligible differentia, a clear basis for classification, and a rational nexus, a logical link to the object of the act.
Speaking of reservation, that brings us to Articles 15 and 16, which are really the battlegrounds for this issue. Article 15 prohibits discrimination on specific grounds.
Yes, and you should memorize these grounds: religion, race, caste, sex, and place of birth. A good mnemonic is RRCS POB.
And the word only in the text is very important.
Crucial. It says the state shall not discriminate only on these grounds. This implies that discrimination on other grounds, like, for example, residence for a particular job or educational qualification or physical ability, is technically permissible if there is a rational reason for it.
But Article 15 itself has many exceptions, which are forms of affirmative action.
It has evolved significantly through amendments. 15.3 allows the state to make special provisions for women and children. This is why laws protecting women from domestic violence are constitutionally valid. Then 15.4 and 15.5 allowed for reservation in educational institutions for SCs, STs, and socially and educationally backward classes, or SEBCs.
And the most recent addition,
The 103rd Amendment in 2019, which added Clause 15.6 for the economically weaker sections, EWS, providing a 10% quota based primarily on income criteria, not caste.
Moving on to Article 16, equality of opportunity in public employment. This is where the whole Mandel Commission history becomes extremely relevant for Mains.
Indeed, Article 16 guarantees equality in applying for government jobs. But just like Article 15, it has a clause, 16.4, that allows the state to reserve appointments for any backward class of citizens that, in the opinion of the state, is not adequately represented in public services.
And this led to the landmark Indrasani judgment of 1992.
Yes, the Mandel case. The court upheld the 27% reservation for OBCs, but laid down some very strict rules, the guardrails for reservation policy. First, the creamy layer, the wealthy and advanced members of a backward class, must be excluded from the benefits of reservation.
Second, the 50% cap.
Right. The total reservation should not exceed 50%, except in very extraordinary circumstances. And third, the court said there should be no reservation in promotions.
But Parliament didn't quite accept that no reservation in promotions part, did they?
No, Parliament fought back using its amendment power. They passed the 77th Amendment to allow reservation in promotions for SCs and STs, then the 81st Amendment to allow backlog vacancies to be carried forward, even if it breached the 50% cap in a particular year, then the 85th Amendment for consequential seniority in promotions.
So it was a constant back and forth.
Constant constitutional dialogue. Finally, the Supreme Court in the M. Nagaraj case in 2006 sort of settled it. They said, fine, you can have reservation in promotions, but the state must prove three things with quantifiable data.
What are those three conditions?
1, you must show the continuing backwardness of the class. 2, you must show their inadequacy of representation in that specific service or post. And 3, you must show that it doesn't adversely affect overall administrative efficiency, which is a condition under Article 335.
That's a perfect example of substantive equality in action.
Yeah.
Now, what about Article 17, the abolition of untouchability?
This is a unique and absolute right. There are no reasonable restrictions here. You cannot say you are practicing untouchability in the interests of national security or for public order. It is banned, period. It is an offense punishable by law.
But the Constitution doesn't actually define the word untouchability.
It doesn't. But the Mysore High Court clarified that it refers to the historical social practice of discriminating against people based on their birth and certain castes. It's not just about not touching someone, it's about social disabilities and exclusion. And to enforce this, Parliament has enacted two powerful laws: the Protection of Civil Rights Act, 1955, and the much stricter SCST Prevention of Atrocities Act, 1989.
And this right is available against private individuals too, not just the state.
Yes, that's a very important point. If your neighbor practices untouchability against you, you can take them to court.
And to round off the right to equality, we have Article 18, which abolishes titles. No more Rai Bahadurs or knights.
Correct. The state cannot confer any titles except those that are military or academic distinctions. We are a republic of equals, not a monarchy with a feudal aristocracy, so titles like general or doctor are fine.
What about the Bharat Ratna and the Padma Awards? That's a common question.
It is. In the Balaji Raghavan case, the Supreme Court held that these are national awards given for merit, not hereditary titles, so they are valid and do not violate Article 18. However, the court also said that you cannot use them as a prefix or suffix to your name.
So you can't have it on your passport or business card.
Exactly. You can't sign your checks or book flight tickets as Bharat Ratna Sachin Tendulkar. That would be a misuse of the award.
Right. Let's move to the second big cluster of rights. The right to freedom, Articles 19 to 22. Article 19 is massive. It grants 6 fundamental freedoms, but only to citizens.
That's right, only for citizens. And I always tell students to visualize the story of a young, articulate Indian citizen, let's call him Uday, to remember the sequence of these 6 freedoms.
A mnemonic story.
Yes. So first, under 19A, Uday wants to express himself. He has the freedom of speech and expression. This isn't just speaking. It includes the right to remain silent, the freedom of the press, and even, as the Supreme Court ruled in the Anuradha Basin case regarding the J&K shutdowns, the right to access the internet as a medium for business and expression.
Okay, so he speaks. Then what?
He finds other people who agree with his ideas. So under 19A, they assemble peacefully and, importantly, without arms.
And after they assemble?
They decide to formalize their group. So under 19C, they form an association or a union. Or, after the 97th Amendment, a cooperative society.
Speech Assembly Association, what's next?
They want to spread their message across the country. So under 1909, they move freely throughout the territory of India. While traveling, under 1901, they find a nice place and decide to reside and settle there.
And finally?
Finally, to survive there, they need to earn a living. So under 1901G, they have the right to practice any profession or to carry on any occupation, trade, or business.
And it's important to remember that there used to be a 1901F.
Yes, the right to property. It was removed from the list of fundamental rights by the 44th Amendment in 1978. It is now just a legal or constitutional right under Article 300A, but not a fundamental one. This means you can still go to a high court if your property is taken, but not directly to the Supreme Court under Article 32.
But Uday can't just do whatever he wants in the name of these freedoms, right? There are reasonable restrictions.
Absolutely crucial for Mains. None of these rights are absolute. Your freedom of speech, for instance, can be restricted on grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense.
So you can't use free speech to incite a riot.
You cannot. Freedom of speech is not a license to abuse, defame, or endanger the nation.
A common query that comes up is about the right to protest versus the right to strike. How does Article 19 see them?
A very pertinent question. You have a fundamental right to protest peacefully. That flows from your freedom of speech and assembly. However, you do not have a fundamental right to strike or to cause a ban that cripples public life and infringes on the rights of other citizens. The Supreme Court has been very clear that while dissent is the safety valve of democracy, shutting down the country is not a fundamental right.
And restrictions on movement.
Yes, your freedom of movement can be restricted either in the interests of the general public, say, during a pandemic, or, very specifically, to protect the interests of any scheduled tribe. You can't just go and settle in a protected tribal zone in the Northeast or the Andaman Islands, as that could destroy their unique culture.
Okay, let's move to Article 20. This protects people who are accused of crimes.
Yes, it provides 3 powerful shields for anyone facing criminal charges, and this is available to both citizens and foreigners. First, no ex post facto law.
Meaning you can't be punished for something that wasn't a crime when you did it.
Exactly. If you commit an act today that is not a crime, the government cannot pass a law tomorrow, making it a crime retrospectively, and then punish you for what you did yesterday. Importantly, this protection applies only to criminal laws, not to civil or tax laws.
Says the second shield.
No double jeopardy. You cannot be prosecuted and punished for the same offense more than once. If you've been acquitted or convicted by a court of law, you can't be dragged to court again for that exact same act. But note, departmental inquiries are different from judicial proceedings. A government servant can be jailed by a court and also fired by their department for the same act of corruption. That is not considered double jeopardy.
And the third, protection.
No self-incrimination. You cannot be compelled to be a witness against yourself. This is the right to remain silent. The police cannot beat a confession out of you. This is also why narcoanalysis, brain mapping, and lie detector tests are considered unconstitutional unless they are administered with the full consent of the accused.
Now for the big one, Article 21, protection of life and personal liberty.
This is, without a doubt, the most dynamic, the most expansive, and the most interpreted article in the entire Constitution. It simply says, no person shall be deprived of his life or personal liberty except according to procedure established by law.
And the interpretation of that last phrase, procedure established by law, has changed dramatically over time.
Dramatically. Initially, in the A.K. Gopalan case of 1950, the Supreme Court took a very narrow, literal view. They said that if Parliament passes a law, any law, and follows the correct procedure for passing it, they can take away your life or liberty. It was a procedure established by law approach, which is a British concept. It didn't matter if the law itself was unfair or unreasonable.
But then came the landmark case of Maneka Gandhi versus Union of India in 1978.
A watershed moment in our constitutional history. The court effectively imported the American concept of due process of law into Article 21. They said the procedure must not just be established by law, it must also be fair, just, and reasonable.
So the law itself can be questioned for its fairness.
Precisely. You cannot have a law that says the police can shoot anyone wearing a red hat. That law might follow the correct legislative procedure, but it is arbitrary and unjust. After Maneka Gandhi, Article 21 exploded in its scope.
What are some of the rights that have been read into it?
So many. The right to privacy, which was declared fundamental in the Puttaswamy case. The right to sleep. The right to livelihood in the Olga Tellis case. The right to a clean environment from the MC Mehta cases. The right to a speedy trial. The right to marry a person of one's choice. It has become an umbrella right that covers almost every aspect of a life with human dignity.
And nested right next to it, we have Article 21A.
Yes, the right to education. This was added by the 86th Amendment in 2002. It makes free and compulsory education a fundamental right for all children between the ages of 6 and 14. This was later operationalized through the Right to Education Act of 2009. It's really the only fundamental right that places a direct, massive financial burden on the state to provide a specific service to citizens.
Let's discuss Article 22, which deals with protection against arrest and detention. This is often confusing for students because it covers two very different things: punitive and preventative detention.
Correct. And it's essential to keep them separate in your mind. Punitive detention is punishment after you've been tried and convicted for a crime you have already committed. When you are arrested under normal circumstances, you have 3 rights. 1, the right to be informed of the grounds of your arrest. 2, the right to consult a legal practitioner of your choice. And 3, the right to be produced before a magistrate within 24 hours, excluding travel time.
This prevents the police from just locking someone up indefinitely without any judicial oversight.
Exactly. Now, the other type is preventive detention, and this is the controversial part. This is detention without a trial. You are detained not because you have committed a crime, but to prevent you from committing one in the future, usually for reasons of national security or public order.
And laws like UAPA or the National Security Act fall under this.
Yes. The Constitution itself allows for it, but it also sets limits. Normally, a person can't be held under preventive detention for more than 3 months unless an advisory board consisting of high court judges reviews the case and approves a longer detention.
It's often seen as quite ironic that a liberal democracy like India has a provision for preventive detention in its constitution, even during peacetime.
It is. It's often called a necessary evil. The framers of the Constitution, having witnessed the horrors of partition, likely felt that in a country as diverse and potentially volatile as India, the state needs certain tools to prevent chaos before it happens. But the consensus is that it must be used sparingly and be subject to very strict safeguards.
Okay, let's move to the next section, Rights against exploitation, which are Articles 23 and 24.
Article 23 is straightforward. It prohibits traffic in human beings and begar, which means forced labor and other similar forms of forced labor. It bans slavery, selling and buying of humans like goods, and forcing people to work without pay.
Is there any exception to this?
There is one. The state can impose compulsory service for public purposes. For example, military conscription during a war, or mandatory service like election duty. The condition is that in doing so, the state cannot discriminate on grounds only of religion, race, caste, or class.
And Article 24.
Article 24 is the shield for children. It prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activity. This has been strengthened over the years. The Child Labor, Prohibition, and Regulation Amendment Act of 2016 has now banned all forms of employment for children under 14 and has also placed restrictions on the employment of adolescents, those between 14 and 18 hazardous work.
Next, we have the freedom of religion, covered in Articles 25 to 28. India is a secular state. How do these rights reflect that core value?
They are the very embodiment of our unique brand of secularism, which is part of the basic structure. Let's break them down. Article 25 guarantees the individual right to religion. It gives every person the freedom of conscience, your inner belief, and the right to freely profess, to declare your faith openly, to practice, to perform rituals and ceremonies, and to propagate your religion, to spread its tenets to others.
The word propagate often leads to controversy. Does it include the right to convert people?
A major point of clarification is needed here. The Supreme Court, in the Stanislaus case, held that the right to propagate does not include the right to convert another person by force, fraud, or allurement. Why? Because the other person also has a freedom of conscience under the same Article 25, forcible conversion would violate their fundamental right.
And these religious rights are not absolute.
Not at all. They are subject to public order, morality, health, and this is key other fundamental rights. This is the logic the Supreme Court used to intervene in the Sabarimala Temple entry case. A religious custom, they argued, cannot violate the fundamental right to equality of women.
And Article 26 is the collective right.
Yes. Article 26 is the right for a group. It gives every religious denomination the right to manage its own religious affairs, to establish institutions for religious purposes, and to own and acquire property. Article 27 then says the state cannot compel you to pay any taxes specifically for the promotion or maintenance of a particular religion. Tax money is secular. It cannot be used to fund one specific faith.
And Article 28 deals with schools.
Yes, religious instruction in educational institutions. If a school is wholly funded by the state, like a Kendriya Vidyalaya, absolutely no religious instruction is allowed. If it is a private institution that is merely recognized or aided by the state, religious instruction is allowed, but it must be on a voluntary basis. No student can be forced to attend.
This brings us to Section 6, which covers cultural and educational rights, Articles 29 and 30. These are often called the minority rights.
That's right. Article 29 protects the interests of minorities. It says any section of the citizens residing in India having a distinct language, script, or culture of its own shall have the right to conserve the same. Now, an interesting point here is that while the heading of the article mentions minorities, the text uses the phrase, any section of citizens. So the Supreme Court has ruled that this protects the linguistic rights of the majority as well.
And Article 30 is more specific.
Much more specific. Article 30 is exclusively for minorities, and only religious and linguistic minorities. It gives them the right to establish and administer educational institutions of their choice.
A critical question for Mains often is, can the government regulate these minority institutions? Can they just do whatever they want?
No, they can't. The Supreme Court has clarified this in cases like TMAPI. The right to administer does not mean the right to maladminister. The state can impose reasonable regulations regarding academic standards, sanitation, health, the qualifications of teachers, and so on. But the state cannot interfere in the day-to-day management to such an extent that it destroys the minority character of the institution.
Right. And now we finally arrive at what Dr. Ambedkar famously called the very heart and soul of the Constitution, Article 32.
Article 32, the right to constitutional remedies. Dr. Ambedkar was right, because a right without a remedy is just a wish on a piece of paper. Article 32 itself is a fundamental right. It gives every citizen the power to move directly to the Supreme Court if any of their fundamental rights are violated. The Supreme Court, in this role, acts as the guarantor and defender of the Constitution. It must hear your case.
And to enforce these rights, the court issues what are known as writs.
Yes, we have 5 of these ancient Latin writs that you must know. First, habeas corpus. It literally means to have the body. If the police or even a private person unlawfully detains someone, the court commands, bring that person before us. If the detention is found to be illegal, they are set free immediately. It is the greatest bulwark of personal liberty.
Second.
Mandamus. We command. The court issues this to order a public official, a public body, or a lower court to do their official duty which they have failed or refused to perform. If a district collector refuses to issue a license that he is legally bound to issue, a mandamus can force him to act.
And the next two are related to courts, Prohibition and Certiorari.
Yes. Prohibition is preventive. A higher court tells a lower court or a tribunal, stop, you are exceeding your jurisdiction, do not hear this case. Certiorari is curative. It's issued after the order has already been passed. The higher court says to the lower court, you have already passed an order, but it is illegal or without jurisdiction. We are quashing it.
And the last one is Quo-Warranto.
Quo-Warranto. By what authority? The court uses this writ to inquire into the legality of a person's claim to a public office. It asks the person, how did you get this chair? Do you have the legal qualifications? If they don't, they are removed from office.
And it's worth noting that the high courts also have writ jurisdiction under Article 226.
An excellent point for comparison. In fact, the High Court's writ power under Article 226 is wider than the Supreme Court's under Article 32. This is because the High Courts can issue writs not just for the enforcement of fundamental rights, but for any other purpose, which includes the violation of ordinary legal rights. The Supreme Court under Article 32 can only issue writs for fundamental rights.
That's a very common prelims question.
It is. Now, to wrap up, let's briefly touch upon Section 7, the exceptions and limitations to these rights. Article 33 allows Parliament to restrict or abrogate the fundamental rights of the members of the armed forces, the police, and intelligence agencies.
The rationale being discipline.
Exactly. You cannot have soldiers on the border forming unions and going on strike. Discipline is paramount for national security. Article 34 deals with martial law. If martial law is in force in any area to restore order, fundamental rights can be restricted there. And Article 35 is a small but important point. It states that the power to make laws to give effect to certain FRs lies only with the Parliament, not state legislatures, to ensure uniformity across the country.
And finally, the suspension of rights during a national emergency.
Yes. Under Article 358, as soon as a national emergency is declared on grounds of war or external aggression, the 6 freedoms under Article 19 are automatically suspended. You can't claim freedom of speech to leak troop movements during a war.
And what about the other rights?
Under Article 359, the President can issue an order suspending the right to move any court for the enforcement of other fundamental rights. However, the 44th Amendment in 1978 added a crucial safeguard. Articles 20 and 21 protection in respect of conviction and the right to life and personal liberty can never be suspended, not even during the gravest emergency. The state can never have the power to take away your life without procedure or subject you to double jeopardy.
Before we close, sir, just a final word on the friction that we often see between fundamental rights in Part 3 and the directive principles of state policy in Part 4.
A very important point remains. Historically, they did clash. In the early Champakamdar-Rajan case of 1951, the court said FRs are supreme and will override DPSPs. But over time, the judiciary's view matured. In the Minerva Mills case of 1980, the Supreme Court beautifully stated that the Indian Constitution is founded on the bedrock of the balance between Part 3 and Part 4.
So they're not contradictory.
They are complementary. They are like two wheels of a chariot. Fundamental rights provide for political democracy, while DPSPs aim for social and economic democracy. You cannot truly have one without the other.
So to summarize the key takeaways for the exam, for prelims, you absolutely must remember which rights are for citizens only. That's Articles 15, 16, 19, 29, and 30. Remember the specific writs and their meanings, and remember that the right to property is now a legal right under Article 300A, not a fundamental right.
Good summary.
And for mains, the focus should be on analyzing the tension between rights and their reasonable restrictions. For example, sedition laws versus free speech under Article 19, or the debate on state surveillance versus the right to privacy under Article 21, and of course the ever-evolving reservation debate under Articles 15 and 16.
Absolutely spot on. The Constitution is a living document, and Part 3 is its beating heart. Your understanding of it cannot be static. It must be dynamic, connecting the text of 1950 with the judicial interpretations and societal realities of today. We hope this deep dive has provided you with the conceptual clarity you need to ace the polity section. Remember, do not just memorize the articles. Understand